The Constitution of the United States might have never happened if not for the Bill of Rights. But what is the Bill of Rights? What's its purpose? Why do we have it? And why is it so important? So today I'm going to talk about the Bill of Rights. I'm going to talk about the text of each amendment. I'm going to give some information on each amendment. And then for some of the amendments, I'm going to dive into some important court cases that go with that amendment. So let's dive in. So what is the Bill of Rights? So the Bill of Rights is the first 10 amendments to the Constitution. It explains Americans' rights in relation to the government. It explains civil rights and civil liberties that Americans have, and it sets rules for the government on what the government can and cannot do. The Bill of Rights was built upon text from other documents, such as the English Bill of Rights of 1689, which inspired the right to petition and trial by jury. You have the Magna Carta in 1215, which inspired the right to keep and bear arms and prohibited cruel and unusual punishment. And then you also had existing state constitutions, specifically Virginia's Constitution. So who created the Bill of Rights and why? So the Bill of Rights was actually proposed during the ratification of the Constitution. But why was the Bill of Rights proposed? So the Constitution lacked limits on government power, and the Federalists wanted a strong national government. The Anti-Federalists wanted the power to remain with the state and local levels, and they favored a Bill of Rights to safeguard individual liberties. So the Bill of Rights was written by James Madison, who was in the U.S. House of Representatives at the time, to address the objections by the Anti-Federalists. Madison was worried that the Constitution would not be ratified if these amendments weren't added. So the House would actually approve 17 amendments. Of the 17 amendments the House approved, the Senate would approve 12 of them, which were sent to the states for approval in 1789. 10 of those 12 amendments were eventually adopted or ratified. Virginia's legislature was the final state legislature to ratify the amendments, approving them on December 15th, 1791. So let's talk about the Bill of Rights. I'm going to start with Amendment number 10 and work to Amendment number 1. The 10th Amendment. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So the 10th Amendment is saying that the federal government only has the powers delegated to it by the Constitution. If it isn't listed, it belongs to the states or to the people, i.e. states' rights. So the 10th Amendment is also known as like the Forgotten Amendment. The Anti-Federalists required this amendment before they would ratify the Constitution. They felt that it was necessary to keep the federal government from becoming too strong. Justices and political commentators have publicly wondered whether the 10th Amendment retains any legal significance. Like, is it something that is even playing a part in today's world? In 1992, the Supreme Court ruled that the 10th Amendment prohibits the federal government from forcing states to pass or not pass certain legislation or to enforce federal law. The 9th Amendment. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So the 9th Amendment is pretty much saying that listing specific rights in the Constitution does not mean people do not have other rights that are not specifically spelled out. So an example of this, and it's kind of a funny example, is like the Constitution doesn't say what color shirt you have to wear. So if you want to wear a purple shirt every day, you have the right to wear a purple shirt every day. So some of the founding fathers became concerned that future generations might argue that because a certain right was not listed in the Bill of Rights, that it did not exist. And they wanted to make sure that there were safeguards so like future politicians couldn't say, well, it's not in the Bill of Rights that you can drive a truck, so you're not allowed. Like they wanted people to know and to understand they had more rights than what were in the Constitution. The 9th Amendment, though, has rarely played any role in U.S. constitutional law or in any court cases. Almost every court case that has come up with the 9th Amendment has also been intertwined with other amendments. It's not just a 9th Amendment case. It might be like a 9th Amendment and a 7th Amendment or a 2nd Amendment. So the 9th Amendment really hasn't played much in court cases. The 8th Amendment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Pretty much what it's saying is it bars excessive bail and fines, and it bars cruel and unusual punishment. So the 8th Amendment is almost identical to a provision in the English Bill of Rights of 1689, which says, and I quote, "As their ancestors in like cases have usually done, The excessive bail ought not to be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. The English Bill of Rights did not discuss bailable and non-bailable offenses, so the Eighth Amendment interpreted that to mean bail can be denied if something is a really serious crime like attempted murder or something like that. So Abraham Holmes and Patrick Henry raised objections to make sure that the cruel and unusual punishment part was in the Eighth Amendment. Holmes and Henry feared that the federal government would misuse its powers to prosecute people with federal crimes that the government did not like, and also use it as a way to oppress people from speaking out against the government. So Holmes and Henry were like, we need this in here because we are scared the government is going to abuse its power. So one of the Eighth Amendment court cases that I found was called Atkins v. Virginia from 2002. And the question in the case was, is the execution of a mentally disabled person cruel and unusual punishment prohibited by the Eighth Amendment? So this was a 6-3 opinion, and the court held that executions of mentally disabled criminals are cruel and unusual punishments prohibited by the Eighth Amendment. So the court ruled there was a concern that mentally disabled people had a lessened culpability to understand what was going on, and that the death penalty was a cruel and unusual punishment for them. The Seventh Amendment. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. The Seventh Amendment is pretty much saying that it extends the right to a trial by jury in federal civil cases. So the Seventh Amendment is generally considered like a really straightforward amendment, but it does talk about multiple different things. One of the things it talks about is jury size. So the Supreme Court found that a 6-member jury was significant to meet the amendment's requirements. This was found in a case from 1973, Colgrove v. Batten. There is a $20 requirement in this case, but there's very little historical evidence to exist to interpret what the amendment's reference is to the $20. There was a law professor, Philip Hamburger, who said that the $20 requirement was intended to become obsolete by inflation. Do we really know that? No, we don't. But if we looked, $20 in 1800 is equivalent to almost $500 in 2024. And then another part of the Seventh Amendment is re-examining of facts. So the Seventh Amendment also prohibits the overturning of a jury's findings of facts of appeals to federal cases, state cases involving federal law, and to the review of the state's cases by federal courts. So this is pretty much saying that it forbids the court from overturning the jury's decision except if there are legal errors or evidence was submitted insufficiently in some way. Like the Ninth Amendment, the Seventh Amendment really has not had a court case of its own. It's always combined with another amendment as kind of like the forerunner in the court case. The Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by the impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature of the case of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So the Sixth Amendment is pretty much saying that accused people have additional protections, such as right to a speedy and public trial. They have the right to an impartial jury in criminal cases. They have the right to be informed of their charges. Witnesses must face the accused, and the accused is allowed to have his or her own witnesses and to be represented by a lawyer. So probably the most well-known part of the Sixth Amendment is the right to a criminal defense lawyer, which is intertwined with the Fifth Amendment's right to an attorney. So the right to legal counsel in a criminal prosecution means the government will pay for you to have a public defender if someone cannot pay for one themselves. The Sixth Amendment requirement of a criminal defense lawyer, however, does not apply until after the defendant has been charged with a crime. The government, though, will not appoint and pay for a public defender in a criminal case where the penalty is just like merely a fine. So the Sixth Amendment guarantees criminal defendants 9 different rights: the right to a trial by an impartial jury, the right to a speedy trial, the right to a public trial, the right to notice of charges, the right for a jury to see and hear witness testimony and view the evidence against a defendant, the right to be present at trial and while the jury hears the case, the right to see, hear, and cross-examine the witnesses against them, the Confrontation Clause, the right to call witnesses to testify and to have the court issue subpoenas to compel witnesses to appear, and the right to testify for oneself in court should they choose to do so. The Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So the Fifth Amendment is pretty much saying, there's a lot of different parts, but it's pretty much saying that serious criminal charges must be started by a grand jury. A person cannot be tried twice for the same crime. This is what you hear as double jeopardy. A person has a right against self-incrimination. A person cannot be imprisoned without due process of law, which is Fair Procedures and Trials Clause. And a person cannot have their property taken away without just compensation. Let's talk about a couple of these little parts in the Fifth Amendment before I dive into some court cases. So the Double Jeopardy Clause, which says a person cannot be tried twice for the same offense. So this prevents an accused person from being tried again on the same or similar charges following an acquittal or a conviction. A different offense may be charged on the same evidence at a second trial, and that is not considered double jeopardy. And then I also want to hit on the just compensation, which is also called the Takings Clause. It is the last clause in the Fifth Amendment, and it limits the power of eminent domain by requiring just compensation to be paid if private property is taken for public use. This is the only clause in the Bill of Rights that was solely drafted by James Madison. He thought this was very important because he didn't want the government just coming in and taking people's land. So one court case with the Fifth Amendment is called Cleo v. New London from 2002. So the question in this case was, does a city violate the Fifth Amendment's taking clause if the city takes private property and sells it for private development in hopes that the development will help the city's bad economy? So this was a 5-4 opinion, and the majority held that the city's taking of the private property to sell for private development qualified as public use within the meanings of the taking clause. It said that the city was not taking the land simply to benefit a certain group of private individuals, but it was following an economic development plan. The Fifth Amendment does not require literal public use, is what the majority said, but the broader and more natural interpretation of public use as public purpose. And another case with the Fifth Amendment is one we've probably all heard of, which is Miranda v. Arizona from 1966. And the question in that case was, does the Fifth Amendment's protection against self-incrimination extend to the police interrogation of a suspect? So this was also a 5-4 decision, and the court said the Fifth Amendment requires that law enforcement officers advise subjects of their rights to remain silent and their rights to obtain an attorney during investigations while in police custody. The Fourth Amendment, the right of the people to be secure in their persons, homes, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So the Fourth Amendment, common speak, is saying that it bars the government from unreasonable search and seizure of an individual's private property, and it also lays out the parameters of issuing a warrant. So a couple court cases with the Fourth Amendment. One of them is called Michigan Department of State Police versus Sitz, might be saying that name wrong, in 1990. And the question was, did the drunk driving checkpoints violate motorists' privacy protected by the Fourth Amendment? So this case was a 6-3 decision, and the court said that roadblocks do not violate the Fourth Amendment. And these are the reasons, and I quote, "No one can seriously dispute the magnitude of drunken driving problem or the state's interest in eradicating it." And the court also said, "The weight bearing on the other scale, the measure of the intrusion on motorists stopped briefly at a sobriety checkpoint is slight." So it's saying that sobriety checkpoints do not go against someone's Fourth Amendment right. So this next case is called Arizona v. Hicks from 1987, and I find it very interesting. So the question was the search of stereo equipment, a search beyond the reason of original entry, reasonable under the 4th and 14th Amendments? Backstory: a bullet went through the floor of an apartment building. To investigate the shooting, the police entered the apartment and they found 3 weapons. During the search, the police saw some really expensive stereo equipment and they suspected it had been stolen. So the police moved the stereo equipment, recorded the serial number, and then seized it upon learning that the stereo equipment was stolen. So in a 6-3 decision, the court said no, it was not a reasonable search. Justice Scalia upheld the plain view doctrine, which allows police under some circumstances to seize evidence in plain view without a warrant. But they said, since the officer who seized the stereo equipment only had reasonable suspicion and not probable cause to believe the stereo equipment was stolen, the officer's actions were not reasonable under the Fourth Amendment. I think that's just a really interesting case. The Third Amendment. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war be in a manner to be prescribed by law. So it's pretty much saying that it prevents the government from forcing homeowners to make soldiers be able to stay in their houses during times of peace. So this amendment is in response to the Quartering Act passed by the Parliament of Great Britain upon the buildup to the American Revolution. The Quartering Act had allowed British Army soldiers to lodge in public buildings even if the people didn't want them there. This amendment is one of the least controversial amendments of the Constitution and is rarely litigated. But in 1993, historian Tom Bell argued that quartering of American soldiers during the War of 1812 and the American Civil War violated the Third Amendment. Though this was never presented in court during the war to be like, hey, my Third Amendment right was violated, it was never brought to court. But following the Civil War, the Army did compensate property owners for rent and damages that may have happened, which kind of kept possibly Third Amendment cases from being filed. The Second Amendment. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So the Second Amendment protects the right to keep and bear arms. There is a lot I could cover with the Second Amendment, but I'm going to try to keep it short and simple. So the Second Amendment was primarily based off the right to keep and bear arms in the English common law and was influenced by the English Bill of Rights of 1689. In Federalist Number 46, James Madison wrote, "How a federal army could keep check by the militia, a standing army would be opposed by militia," saying that a militia could keep a standing army in check to make sure they're not doing things they're not supposed to be doing. He argued that state governments would be able to repeal the danger of a federal army. Before I go into this amendment, I do want to explain what the Heller case is from 2008. I will mention it a few times while I discuss the Second Amendment because it does play a huge role in Second Amendment rights. So the Heller case was called District of Columbia v. Heller, and it was a case from 2008. So the background of the case, parts of the District of Columbia Code made it illegal to carry unregistered firearms and prohibited the registration of handguns, though the chief of police could issue a 1-year license for handguns. The code required owners of lawfully registered firearms to keep them unloaded or disassemble or bound by a trigger lock or other similar device unless firearms were located in a place of business or being used for legal recreational activity. So this case comes about because of a man named Dick Heller, who was a DC special police officer who was authorized to carry a handgun while he was on duty. So he applied for a 1-year license for a handgun he wished to keep in his home, and he was denied. So he would then go and sue the District of Columbia. He sought an injunction against the parts of the code that were infringing upon his rights, and he argued that the code violated his Second Amendment right to keep a functional firearm in his home without a license. The district court dismissed the complaint and threw it out. The U.S. Court of Appeals for the District of Columbia Circuit reversed the decision and held that the Second Amendment protection of rights to keep firearms in a home for the purpose of self-defense and the District of Columbia's requirement that firearms be kept in the home be non-functional violated that right. So they're saying the U.S. Court of Appeals for the District of Columbia Circuit said you have the right to keep a firearm in your home for self-defense. But the District of Columbia was saying, no, if you have a firearm in your home, you can't even have it loaded. So when it got to the Supreme Court, the question was, do the provisions of the District of Columbia's code that restrict the licensing of handguns and require licensed firearms kept in the home to be kept unfunctional violate the Second Amendment? So this was going to be a 5-4 decision. So the majority said, the ban on registering firearms and the requirement to keep guns in the home disassembled or non-functional with a trigger lock mechanism violates the Second Amendment. The majority also said the term militia should not be confined to those serving in the military because at the time, the term referred to able-bodied men who were able to be called upon in times of service. The majority also said that to read the amendment as limiting the right to bear arms for only those in the military would create the exact type of state-sponsored force that the Second Amendment was written to protect the people against. So the majority said that banning handguns, an entire class of arms that is commonly used for protection purposes, and prohibiting the firearms to be kept functional in the home, the area traditionally like that you're going to use your firearm for protection, violates the Second Amendment. So Heller is a very important case. Anytime you hear Second Amendment cases being discussed, Heller is probably going to be talked about. So I want to go back in time before I dive into some recent court cases with the Second Amendment and talk about America before the Constitution and how the Second Amendment kind of was born. So King Charles had authorized the use of armed special defense and safety on land and at sea against destructive forces, invasive forces, detrimental forces, and annoying forces. So early Americans had other uses for firearms beside those that King Charles had in mind, such as safeguarding against tyrannical governments, suppressing insurrections, and facilitating a natural right of self-defense. So King George III would begin disarming individuals who were seen as rebellious or individuals who were in rebellious areas in the 1760s and 1770s as an effort to disarm colonial patriot militias because he was worried about this upcoming revolution, the talk that he's heard, and he wanted to try to take their arms away so they could not fight back. So in the Second Amendment, when it comes to a tyrannical government, Noah Webster, an author, said, and I quote, "Before a standing army can rule, the people must be disarmed. As they are in almost every kingdom in Europe, the supreme power in America cannot enforce unjust laws by the sword, because the whole body of the people are armed, and constitute a force superior to any band of regular troops that can be, on any pretense, raised in the United States." George Mason also argued the importance of the militia and the right to bear arms by reminding people of the British government's effort to disarm the people. So he was like, hey, this is really important because remember, the British tried to do this. So the Second Amendment would be debated for months on what is the correct wording of the amendment. So in the Second Amendment, the meaning of well-regulated militia. In the early years, the term regulated meant disciplined or trained. In the Heller case, though, the Supreme Court said, and I quote, "The adjective well-regulated implies nothing more than the imposition of proper discipline and training." When it comes to the meaning of, thumbs up. When it comes to the meaning of the rights of the people, Justice Anthony Scalia, writing for the majority in Heller, stated, and I quote, "The Second Amendment surely elevates above all other interests the right of law-abiding, responsible citizens to use arms in self-defense of hearth and home." The majority in Heller also said, and I quote, "If protecting militias had been the only reason, then the amendment could have instead referred to the right of the militia to keep and bear arms instead of the right of the people to keep and bear arms." And then also, what does the meaning of keep and bear arms mean? So in Heller, the majority rejected the view that the term to bear arms implies only to military use of arms, and they said the term arms was applied then, as now, to weapons that were not specifically designed for military use and not employed by military capacity. To keep arms in the Second Amendment is to have weapons, and to bear means to carry. The justices in the dissent of Heller said that if the framers wanted citizens to have weapons, not just the militia, they could have easily added another sentence. Before 1820, the use of the phrase bear arms was commonly used in a civilian context, such as for hunting and personal self-defense in both British and American law. So let's talk about some Supreme Court cases that happened after Heller. So one case was the United States v. Miller in 1939, and the question in that case was, does the Second Amendment protect an individual's right to keep and bear a sawed-off double-barrel shotgun? In a unanimous decision, the Supreme Court reversed the district court's ruling, holding that the Second Amendment does not guarantee an individual's right to keep and bear a sawed-off double-barrel shotgun. Justice James Clark McReynolds reasoned that because possessing a sawed-off double-barrel shotgun does not have a reasonable relationship to the preservation or efficacy of a well-regulated militia, the Second Amendment does not protect the possession of such instrument. And then you have, and the last case I'll talk about is one of the most recent cases known as the New York State Rifle and Pistol Association v. the City of New York, also known as Bruin. So the question in this case was, does a New York City rule banning the transportation of licensed, locked, and unloaded handguns to a home or shooting range outside city limits violate the Second Amendment, the Commerce Clause, or the constitutional right to travel? So in an unsigned opinion, the court ruled that this case was kind of moot because the city had actually changed its rule before the final hearing of the case. And so they felt like some people in the Supreme Court felt that it was it's a non-conversation now. The city changed its rule, it doesn't matter. Justice Alito argued that the court should not have dismissed the case and should have actually went ahead and made a decision, because then that decision would have affected possibly cases in the future. The First Amendment. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peacefully to assemble and to petition the government for a redress of grievances. How we see it, how we read it today in our common language is, you have the right to free speech and to freedom of press. You have the right to assemble and to gather in a group to protest and for other reasons, and to ask the government to fix your problems with petitions. You have the right to have whatever religion you want, and it prevents the government from favoring or creating a state-sponsored religion. So I'm going to break down some of these parts of the First Amendment. Freedom of assembly and petition. So the petition clause protects your right to petition the government, to right a wrong, you have the right to tell them your grievances. You have the right to tell them you don't agree with something. Assembly. So the right of assembly is the individual's right of people to come together, to collectively express ideas, to promote ideas, to defend ideas, to talk about ideas. So you have the right to assemble with people. Freedom of religion. So it is said that the right of all persons to believe, speak, and act individually and in community with others in private and in public in accordance with their understanding of ultimate truth. That is what it is perceived of freedom of religion. So the freedom of religion, like I said, prohibits the government from making an established state religion. So the government can't come in and today and say, everybody's gonna be Hindu now, and that's what we're sponsoring. They can't do that for any religion. The freedom of religion also keeps the government from interfering with your religion. You have the right to practice any religion you want to practice. Now, if your religion, though, is saying you need to go sacrifice children on the street, then the government can step in and be like, no, like you can't do that. But as long as you're not hurting someone, the government cannot tell you how to practice your religion. Thomas Jefferson, when it came to this part of the First Amendment, was very adamant that religion is a matter which lies solely between man and God, that the legislature should make no law respecting an establishment of religion or prohibiting the free exercise thereof, and that there should be a wall between church and state. Freedom of speech. We hear about freedom of speech all the time. So what does freedom of speech mean? So freedom of speech means the free and public expression of opinions without censorship, interference, or restraint by the government. When it comes to freedom of speech with political speech, the First Amendment protects the rights to criticize even the most prominent politicians and leaders without fear of retaliation. You also have freedom of press, which freedom of press means the right for individuals to express themselves through publications of information, ideas, and opinions without fear of interference, constraint, or prosecution from the government. So to wrap up the video, I'm going to talk about 3 First Amendment court cases. The first one is a court case from 2022, which was 303 Creative LLC versus Linus. I might be saying that last name wrong. And the question in the case was, does application of the Colorado Anti-Discrimination Act to compel an artist to speak or stay silent violate the free speech clause of the First Amendment? So in a 6-3 opinion, the court said that the First Amendment prohibits Colorado from forcing a web designer to create a design that conveys a message which the designer disagrees with. So it was saying that the state cannot force someone to make a web page for a group or a particular people that they don't agree with, maybe their lifestyle, maybe their cause, and that you can't be forced to do that. The second case is West Virginia State Board of Education v. Barnett from 1943, which is a case from my home state. And the question was, does the compulsory flag salute for public school children violate the First Amendment? And in a 6-3 opinion, the court held that compelling public school children to salute the flag was unconstitutional. So when we do the Pledge of Allegiance every morning at school, the students are not forced to stand to do the pledge. They are allowed to sit to do the pledge, but they do have to be respectful while the pledge is going on. And then the last case I'm going to talk about is the Town of Greece versus Galloway from 2014. And the question in that case was, does the invocation of prayer at a legislative session violate the Establishment Clause of the First Amendment, even in the absence of discrimination in the selection of prayer givers and content? In a 5-4 opinion, the court held that the context and jurisprudence surrounding the First Amendment suggestion of the Establishment Clause was never meant to prohibit legislative prayer. And although the respondents in this case testified that the prayer offended them, Justice Kennedy distinguished between offense and coercion and noted that the former does not violate the Establishment Clause. So the Bill of Rights. I maybe talked a little bit more than I had planned, but you know what? Sometimes that just happens. The Bill of Rights impacts us every day, whether we realize it or not. And most of the time we don't realize it. And we need to understand why the Founding Fathers put these rights in place to protect us and to protect our nation. So some questions to think about, and maybe drop your answers or your thoughts in the comments. Does a state have the right to not uphold an amendment? What does an impartial jury of your peers really mean? Someone in the same job as you, the same background, the same age? How quickly do you think a speedy trial should happen? When does free speech become dangerous? And a last question, because I've seen this talked about in other forums. If a city or state restricts your right to bear arms in public and you get attacked, should you be able to sue the city because you could not protect yourself? If you enjoyed today's video and you want to see more videos like this one, please like, subscribe, and comment below, either like maybe answering the questions I just asked or just what your opinion is on the Bill of Rights.